This case is a statute of limitations case involving FIGA. There was, and I go to simply regurgitate that which is in the brief, so I won't bore you with that. I'll simply establish a brief timeline. I believe that the summary judgment that was entered in FIGA's favor, granting summary judgment, was an error for a variety of reasons. The first was that we have a certain standard that exists at an MSJ hearing. The movement comes in and must establish, has the burden to establish, that there is no genuine issue of material fact, and it's entitled to judgment as a matter of law.
And you think there's an issue of fact on extension? Is that what you think?
Well, I think whatever the issue may be, that it is entitled to judgment as a matter of law. And in this case, their argument was the statute of limitations set forth in 631-68 does apply to this action, and the court ultimately barred this action. Our position obviously was that it did not. And that was stated at the hearing. One of the theories that was asserted there was that it applied to third parties, to first parties. That was one component of the theory. But at the bottom, there was a deadline on May 2nd, 2012, within which FIGA says, and was candidly, the statutory deadline for filing suit. However, there was a coverage determination made until 2 days after that point. The statute provides a one-year statute, well, actually it's a 2-year, 1 year to file a claim, which was timely done in this case, and then another year within which to file suit. Extension is included. The coverage determination made 2 days after that deadline, making payment confirming a covered loss at this property to the tune of $94,000 plus $6,000 in cosmetic damages, raises that issue. Now, our position has been that statute of limitations does not bar recovery to this action. There have been issues raised. Well, was it pled as an avoidance, and was it all these different things? It didn't need to be pled as an avoidance.
At least as to your argument that it doesn't apply to first-party claims, that really isn't an avoidance argument, I don't think.
Well, Your Honor, that is correct. But the concept that the statute of limitations does not bar this claim is what the position was. They alleged affirmative defense, statute of limitations applies to this case. We didn't have to, because the default state is denial of that.
Well, if your contention was that in fact the statute of limitations didn't apply because no coverage determination had yet been made, and so the clock didn't even start running, wouldn't that necessarily be an affirmative defense to, or a reply, an avoidance to their affirmative defense?
Your Honor, I don't really think that it would be. The idea is, the allegation is statute of limitations operates to bar plaintiff's claim. Our position is that it does not. The idea that the statute of limitations hasn't even begun to run yet is just a direct denial of the assertion that the statute of limitations applies to this claim.
Is there any case law on this? I mean, the IGA statutes are a uniform law, so they're versions similar to this. I don't know whether 631-68 at this point is standard ULA law or not, but it would seem, I mean, I understand your problem is that the claim was not being adjusted by the carrier. The claim was being adjusted by FIGA, and they wait until actually after the so-called 2-year period to tell you the bad news, which is when you really need to file your lawsuit. Is there case law that says that they can't do that, or that you must file a first party as compared to a third party action even before you know whether you got a problem or not?
There's not any case law that I'm aware of, and we look for that very thing, because that's really what the core of this issue is. And Your Honor, I happened to say it this morning, that just seems problematic.
Yeah, it does. Yeah.
The law is that FIGA can simply wait until after this 2-year period to make its claims determination, and either
But is that
deny your
not the
claim.
purpose of the statute of limitations? If you feel they are not doing what they're supposed to, don't you have a cause of action? And
Your
in
Honor,
fact, let's talk about what 95.11 says, which is an action, there's a 1-year period for an action against any guarantee association and its insured, with the period running from the date of the deadline for filing claims in the order of liquidation. It doesn't say within 1 year from the date of a coverage determination or a coverage denial. It says the filing of claims.
well, Your Honor,
How does that not start the clock running?
not to avoid your question, but I want to answer it directly, but I need to back up just a little bit. First of all, Chapter 95 starts with the general premise that the cause of action at some point accrues. The cause of action has to accrue and begin the time running.
Well, and I'll let you go on, but just as to that specific point, why is it not a reasonable understanding of the statute that if your client's getting jerked around, its cause of action arises because you filed a claim and they're doing nothing?
Well, that's an interesting point. Even Your Honor was part of the Penny decision that discussed the 631.70 attorney's fees provision that says FIGA can't be held liable for attorney's fees unless they deny a claim by some affirmative act other than mere delay. And so FIGA is a different creature. FIGA doesn't get held accountable, as it were, for merely delaying. There are investigations that are in play according to the statutory protocol, and they get their opportunity to essentially renew the claims investigation process. In fact, in this case, they got another engineer involved to look at the sinkhole problem anew and came back and confirmed the sinkhole when the underlying carrier had denied the sinkhole. So as close as I can to come to hitting the mark and answering your question, Your Honor, at some point the cause of action accrues. FIGA by the statutory construct isn't held accountable for merely delaying the claim. At some point, as trial counsel, have a reasonable factual basis to even file a complaint. And in this case, it was they didn't make the coverage determination later, but then they made a $6,000 payment for cosmetics, which we believe to be woefully inadequate. But at that point, that they had made their claims decision, confirming sinkhole. Their engineer said it's going to take $94,000 to fix this property, but they made their payment of the ACV, and I won't bore the court with that whole sinkhole, which I've been before you.
I think this same goes back to, you're giving us a lot of information that was not raised as an avoidance of the affirmative defense. And the purpose of an avoidance is to bring factual information to the court to reflect that the affirmative defense does not prevail.
But Your Honor, the facts were presented to the trial court. Trial counsel brought with them or the notice of filing prior to the hearing of that check that was dated after this.
Well, but you also, trial counsel also filed a copy of several documents, one of which is the proof of claim form, which on its face says the claims filing deadline is May 2, 2011, which seems to be a document consistent with 631.68, which says you have to file it within 1 year after the deadline or any extension. The only evidence of record is, here's the deadline. There's nothing of record indicating any extension of the deadline in which to file the claim.
And if Your Honor's inquiry is regarding that which was available to the trial court in terms of evidence, I could discuss that. But I think you may be talking about what's actually on the face of the document, and that is consistent with 631.86, which says the claim must be filed within 1 year. The claim and the proof of the claim, the notice of claim, was properly filed in the proper form, timely. The issue is whether or not the suit had accrued by the time that came up, and Judge Altenberg here.
But the statute says that basically suit has to be filed within 1 year after the deadline for filing claims or any extension thereof. Thereof, as I read it, means any extension of that deadline to file claims.
As it does with respect.
So the avoidance that I will tell you, I'm leaning towards finding there's a problem with no avoidance. The avoidance that I think needed to be filed is that in fact the deadline for filing claims was extended to such and such a date, or there was an open extension. And here's the information, Judge, that we're going to submit to you to defeat this affirmative defense.
If I may, one of the cases that counsels, if the court decides that it may be leaning in that direction, or if Your Honor is, I would urge Your Honor to review the Tax versus Kaiser decision. It was actually cited by my colleague that stands for the proposition. In that case, the motion for summary judgment was affirmed on a similar issue, in that there was an affirmative defense raised. It was about conditions preceding that nature. Affirmative defenses were raised. No reply was filed, and the court ultimately said we're going to affirm the summary judgment here, but we're going to do so. We're going to remand for actions consistent herewith, but we're doing this without prejudice and allowing the plaintiff an opportunity to file with the trial court, leave to amend affirmative defenses to raise that very specific issue, because there's no question that there's an issue of fact on that issue, at least. Okay, and that's one of the things that the tax decision indicated, was that if you don't file your necessary reply to affirmative defense, then even if there is a question of fact, that may be an issue for you. And then if you were required to file an avoidance and you did not, it doesn't matter whether it raised. It's not binding on this court, but it is out there, so I will candidly address it.
Mr. Smith, if I can shift gears with you just a little.
Yes,
no. Let's simplify the facts of this. Let's forget about the bankruptcy, and let's just have your barn burned down. It's a standard fire claim on an insurance policy for a burnt down barn. When does a cause of action against your carrier for this first party claim accrue?
All elements of breach of contract.
Swell, I know that part, but when is that? Is it the day the barn burns down, or the day they give you not enough money? When does this cause of action accrue?
If they do something that's in breach of the contract. What I mean by that is, if they deny the claim, and I believe there's been a factual basis, I'm willing to certify in a complaint that's the date.
I mean, there must be case law on this, but
sure.
So if the barn burned down on day one, and 2 years and 2 weeks later, they send me an inadequate check to compensate me for the loss of the barn, do I have 5 years from the check or 5 years from the fire?
5 years from the check. I mean, the occurrence of
because it's a breach of it's a breach of contract claim, not a claim on the contract. So
well, that's what the policy is. That's what the insurance instrument is intended to do.
So your theory, or at least one of your two theories, is that you didn't have a cause of action that accrued for this.
They had not made a coverage determination, and with the typical carrier, one might say, well, your cause of action is delay. Maybe there's a loss settlement provision, or there's some other type of mechanism in the insurance instrument that says within 90 days, we will make payment within 90 days unless we judgment, we work out a settlement with you, or things not beyond our control. That whole loss settlement standard, settlement language, FIGA is different. FIGA is not accountable to do things on a timely basis. FIGA can come in and totally rewash, as they did in this case, the underlying insurance investigation.
For all practical purposes, they're a trustee in bankruptcy, is what FIGA is. So I mean, this runs like a bankruptcy, and sometimes the rules need to be a little more black and white for those kinds of proceedings.
Well, and I think at the end of the day, again, I don't want to go through simply regurgitating the issues that are in black and white. So what I'll say is, you had an issue where there was well, as we look at it, there was a burden on the movement to show no genuine issues of material fact, and that they had not granted an extension by that late payment. They did not do that. They didn't provide any evidence whatsoever. They just simply said, there's the statute of limitations. There's the statute itself. They filed after it. We win. I think as counsel put it earlier, it's not an I move, you prove proposition. Then later there was the court gave some recommendation from counsel to provide some additional case law. There was additional case law raised. Then later, trial counsel said, well, I need an opportunity to put on this, and it does contemplate this. The statute does not apply issue. That didn't occur here. But at bottom, what this case is about is that the statute, that the cause of action had not accrued prior to this time. And as Your Honor very succinctly put it, that just seems problematic. If you have FIGA who can refrain from taking a coverage position until indefinitely, and it's ultimately rewarding FIGA for waiting until that period of time to not make a coverage determination on a confirmed sinkhole. This is a confirmed loss. It's going to take 6 figures to repair this house by anybody that you ask. That's the situation. And not to get into other matters, FIGA's position is, and this is a critical component, FIGA's position is Ms. Betancourt is without recourse. If your honors say, you know what, summary judgment affirmed, and I'm not going to allow you an opportunity to go back and
she may have recourse. It may just not be against FIGA.
Well, fair enough, Your Honor. But the bottom line is FIGA is taking the position that it doesn't need to pay for this claim at all. And that's critically important. There's a covered loss here. And if their position is they can simply step back and say, you know what, I don't even care if you come back and accept our recommendation, you're done. Why? Because there's no recourse that you have on breach of contract action. That just seems problematic.
Before you finish up, I want to ask you one question relating to this argument that a coverage determination had not yet even been made and therefore the action was not yet ripe. Was that either pleaded or developed in front of the trial court?
Yes, it was, Your Honor. There were statements there that the statute did not play.
I mean, it seems to me the focus was in the trial court as it was on the briefs as to whether or not the 1-year period had been extended. And the focus was not, and by the way, the time period never even started because there had been no coverage determination.
Well, my reading of the briefs is that there was a large amount of ink spilled on the issue of the statute of limitations does not apply.
But the specific argument that it does not apply because it had not started running, was that argument developed in the trial court?
It wasn't, when you say developed, it was, I believe the predicate for it was stated. We've cited the case law for proposition.
Well, the predicate is statute of limitations. They lose on the statute of limitations, it doesn't apply. But there are multiple reasons why a statute of limitations might not apply. There could be an extension of time, there could be a waiver, there could be a stipulated agreement that we're not going to assert a statute of limitations as a defense because we're still doing A, B, and C, and you still need to be doing D, E, and F. So was this particular argument that you're making presented to the trial judge?
No, Your Honor, it wasn't, to be direct. However, statements like statute of limitations do not apply were stated not just in the hearing, but also in the follow-up correspondence in response to the court's apparent willingness to...
You've probably already figured out that I'm troubled by the lack of an avoidance.
No, yes, Your Honor, and I would implore the court to review the Tax versus Kaiser decision, where that court said the plaintiff did not provide a required avoidance.
Do you have the cite for that case, Andy?
It's 328-7-2nd, 517 is a court PCA.
Great, thank you.
Mr. Smith, we've kept you busy well beyond your 15 minutes, so let me save you 3 minutes for rebuttal. Will that work? Thank you. Ms. Klein?
Good morning. Cindy Klein here on behalf of FIGA. There are a number of alleged facts that opposing counsel addressed and seen in the record that there is no record support for. There is nothing in the record to establish that either Magnolia or FIGA ever denied coverage for this claim at any point in time.
Right. So let me ask you this. If he files this claim within the 1 year, and 9 months goes by and he hasn't heard anything yet, so he knows FIGA's understanding that he's got 1 year to file his lawsuit, so he files a lawsuit. What is he alleging?
He is alleging that he hasn't been paid.
I have a pending claim and I don't know whether there's a breach of contract or not, but I'm filing my lawsuit just in case my cause of action goes away before I know whether I have it or not. Is that what he files?
He can allege that the underlying insurance company has denied the claim. He can allege.
But the underlying insurance company didn't deny the claim, did they?
That's exactly my point.
Right.
He never denied
So how can he file? You want him to file a lawsuit, but what do you want him to say? Help?
Well, that's not the facts of this case, Judge. There has never been a denial of this claim. There had never, the only alleged breach in this claim.
So, I mean, I'm serious, but by May 2nd or whenever this time runs, he gets his check that is inadequate a week later or something like that, right? So on May 1st, when his time for filing a lawsuit on your theory is expiring, right?
Yeah.
What's he supposed to file as a lawsuit?
At the time that he files a lawsuit, he hasn't been paid for his loss, whether he's been paid less than that amount or
And is that a
no
breach
amount
of,
under
breach
the
of
FIGA
contract
statute.
under the insurance contract?
Well, under the FIGA statute, it's not technically a breach of contract claim.
Right.
It's a claim against FIGA to pay my loss. The loss, according to his proof of loss.
So you want us to write a case that says if I've got a first party claim against an insolvent insurance company and FIGA has taken it over, if you don't hear anything from FIGA in the first 9 months, you got to file a lawsuit against them. So you want first party lawsuits against everybody during the adjustment period.
I
That
personally do not, Judge, and I don't think that that's the facts of this case, and I don't think it's necessary for this court to address it in this case, because it simply isn't the facts in front of Your Honor, and there is no need to address a wider reaching question.
Why isn't it the facts of this case?
Because under the allegations of the plaintiff's complaint in this case, the alleged breach of contract, the thing that they sued on, and that's on pages 6 and 7 and 8 of this record, was that Magnolia had retained the services of an engineering firm, that the engineering firm failed to comply with the standard geotechnical engineering practices, and then they go ahead and allege, and this is at paragraph 25, page 7 of the record, by electing to cover the sinkhole loss as set forth in the insurance policy, the defendant contractually obligated itself to investigate and resolve sinkhole claims in a manner not inconsistent with the insurance statute. And then it goes on to say on paragraph 27, defendant has breached the contract by failing to conduct a proper substantive investigation, failing to pay all amounts due and owing to repair the premises to its pre-loss condition, and failing to work in consultation with the plaintiffs in the testing and remediation of the insurance premises. Nowhere in there is there any allegation, and there's no evidence, that there was any denial of coverage by Magnolia, and as in fact they allege that Magnolia hired an engineering firm to assist it in adjusting this claim, and there's no allegation that FIGA ever said we're not adjusting this claim. So respectfully, Judge Altenberg, I understand your concerns, but that's not the case here. There's simply no allegation of another breach.
Let's assume that this was the case, that these were their allegations, that FIGA refused to adjust the claim. What I'm concerned about is the statutory language which says a covered claim, which has not, the exact language, with respect to which settlement is not affected and suit is not instituted within a year, is barred. And so, I mean, it seems to me the statute contemplates that FIGA might do nothing And if the plaintiff contends it's a covered claim, it does seem to me that the statute is saying if you're going to pursue FIGA, you've got to do it within 1 year, whether they've paid you too little or offered too little, or they've refused to do anything. And I'm not certain if I'm misreading that or reading it too strictly, but there aren't any cases that really talk about this.
No, there aren't.
But it is a change in the typical statute of limitations.
I agree.
And FIGA is unique, and there are certain protections that a homeowner has that they don't otherwise have, and there's, it seems to me, certain detriments that they incur, and this may be one of those.
Well, off the cuff, because this wasn't raised in the briefs, it would seem to me that under the circumstances, they would have to file suit against FIGA, where they might not be able to file suit against an insurance company. At that point, and I see this every day, is that FIGA then comes in and says, let's go to appraisal, let's figure this out. What opposing counsel is arguing was it's not fair because I don't get fees. But he hasn't argued that it's not something that he could have done in this case. The proof of loss in this case was filed some 4 months before the limitations period expired. They knew they had a claim.
Can you file a sinkhole claim against a carrier under the statute before the carrier denies coverage? That statute's changed so many times I get confused.
I believe that, well, most of the sinkhole claims that I see are not about a carrier denying coverage. They're about things like you hired the wrong geotechnical firm, we disagree with the geotechnical firm, and what typically happens is that FIGA appears, there's a neutral evaluation, the case is abated, et cetera, et cetera.
Right.
That's all of the sinkhole cases that I've seen, and again, this is outside the record, Judge, are cases in which FIGA hasn't denied that there's been a sinkhole. It's just a matter of the adjusting process. And there's nothing unique or different about this case at all, but I did want to emphasize to this court that the concept of a denial of coverage just isn't relevant in this claim at all, because even the plaintiff alleged that there was no coverage denied. So there was nothing in this record to establish they could not have at least filed the litigation. And if at that point, I would suggest, if at that point FIGA came in and said the cause of action hasn't accrued, I would certainly say that that would operate as a waiver of their right to then say thereafter the statute of limitations is run. But again, we're getting outside the record in this case, and that's certainly, a hypothetical issue. I would point out opposing counsel argued to this court the tax case. It's the only case that I've seen, and we cited it, and opposing counsel did not address it in the reply brief, where the court reversed and remanded with directions that the plaintiff be permitted to file a reply. It's a single case out there, it's an outlier. Opposing counsel has
Here's an interesting thing about the case, and I was able to call it up as we've been sitting here. The court says, the error which we perceive came about when the trial court did not allow appellants to amend their pleadings, which suggests that they asked for leave to amend, but it was denied. But then the next paragraph says, this affirmance is without prejudice to the plaintiff appellants within a time to be set by the trial court to move for leave to file a reply if they are able.
Well, that might explain why this particular court, and no others, has said that would be a permissible thing on remand where a reply has not been timely filed. It appears from the facts, as Your Honor just stated, that maybe there was a request to amend. In this case, there's certainly never been a request to amend. There hasn't even been a request to amend in the reply brief in this case. And I would submit it's untimely for opposing counsel to now, at oral argument for the very first time, request leave to amend to raise a reply to the affirmative defenses when they had every opportunity to have done so. I think it's clear from this record that the ultimate result in this case, first of all, is absolutely legally correct. There are no reasons why, no evidence of record to raise a genuine issue of material fact. The arguments, the legal arguments that have been raised on appeal, the accrual issue is an argument that was first raised on appeal. The due process argument was never argued to the court on summary judgment, but was only argued in passing in a handwritten letter to the judge after the hearing. But at the end of the day, opposing counsel's sole argument in this case was that the statute of limitations didn't apply because it only applies in third-party cases. That was the sole argument that was raised at the summary judgment hearing. Opposing counsel chose not to file anything in response, no written response to the motion for summary judgment, which they're free to do, but chose to surprise the court and opposing counsel at the hearing.
They did ask for a hearing in their written, I think it was a letter to the court saying, you know, you ought to have a hearing on these additional arguments. The difficulty I have with that approach is, one, it doesn't appear there was an effort to set a hearing by the other side. And then maybe more to the point, I don't see any real significant development of the argument on appeal. So I'm not sure what would have been tendered below that couldn't have been tendered as a question of law here.
I agree, and that was one of the arguments that we raised here, is that it's basically harmless error because as a matter of law, the trial court was correct. Nothing that could have been argued relative to that specific argument would change that. And opposing counsel's position that this was a new argument makes no sense in context. The new argument, the argument that the statute only applies to third-party cases and not first-party cases, was first raised at the hearing by opposing counsel, who did not plead it as a reply. And when the court...
So that's not a factual issue, that's a pure legal issue.
That's a pure legal issue.
They don't have to file a reply as to something that's not factual.
I disagree. If the court, if a party is going to take the position that an affirmative defense does not apply, whether factually or legally, I don't think there's any distinction in the case law with respect to replies. If they're seeking an avoidance...
between an avoidance and a legal reply?
I think a legal reply is an avoidance.
Avoidance is an allegation of fact.
Yes.
And you have to file a reply if it's an avoidance, but do you really think you have to raise that the statute of limitations doesn't apply to first-party claims in a reply?
I do. If the statute of limitations that's been argued is not an appropriate affirmative defense, I don't believe, Judge, and I could be wrong, I haven't researched the issue, but I don't believe that there is any distinction between the facts and the law in reference to whether you have to raise an issue as an avoidance in a reply. It's always been my understanding that where you're seeking to just simply argue, no, the statute of limitations has not run, you would not need to raise that in a reply. That's a simple denial. But if you're seeking to argue that the statute of limitations does not apply, it would seem to me that that would be both, it would be a legal and or, depending on the circumstances, a factual issue that should have been addressed in a reply. But be that as it may, they raised that issue at the hearing. They had every opportunity to argue that issue at the hearing. It was the first time it's ever been raised. The trial judge correctly granted FIGA the opportunity to provide it with case law on that specific issue, which FIGA timely did, only on that issue, without raising a different or a new argument. And then for the first time, the plaintiff's counsel then asks, well, now I want to respond to the case law that you asked for, Judge, at the prior hearing. Well, it would seem to me that unless FIGA raised something completely new or different, that there is no due process right to a hearing. And if they believed that they would need leave to file a reply, they certainly could have and should have done so at the hearing when the court asked FIGA to send in that case. On this record, we don't believe that the trial court erred in any way. We do not believe it appropriate for this court to reverse and remand to give the plaintiff's attorney an opportunity to file a reply that should have been filed well before and which was not requested in the report clause of its brief. And again, we would request that the court affirm this summary judgment in all respects.
Okay, thank you. Mr. Smith?
Very briefly. I don't know how much time I have left, so I will just.
You got 3.5 minutes.
We heard that there is I want to emphasize this point, there was no child coverage. That's the point. There was no action. There was nothing providing the basis for the cause of action. If there had been a coverage determination made, be it we're going to cover, we're only going to pay X, or we're going to deny the claim. That's when the cause of action proves. I understand the new statute of limitations. It is different but that's neither here nor there.
But it seems to me the statute contemplates your scenario because it says a covered claim is defined herein with respect to which settlement is not affected. And why does that not why does that not contemplate simply FIGA's doing nothing? You filed your claim, and if you're unhappy with what's going on, you've got a year if you haven't resolved it.
So is the allegation, Your Honor, as problematic as it may be, if this panel finds that that is what the law is, you find it against it. It's just that simple. But I don't think that's what it stands for. I don't think it stands for the proposition that you set aside your ethical obligations to have a reasonable factor basis for filing a suit simply because a settlement has not been effected. Again, FIGA gets a little bit of a different angle, and they can sit back and do investigations and things of that nature. And if I can file suit on their delay, then there are going to be a lot more suits against FIGA.
You know, Judge Altenberg referred to other potential causes of action, first-party causes of action with an insurer. It's not really ripe until coverage is denied. But if the insurer doesn't do anything, there is a cause of action available.
Because there's a law settlement provision that says, I agree. I tried a lot of cases against insurance companies, so I agree with Your Honor totally. But there is a provision, there's a predicate for that, there's a basis for that. There's a contract that says that thou shalt do certain things within 90 days. There's a time limitation here. And here, that doesn't exist. FIGA is exempt, in effect, from delaying the process, even if it's a patent delay.
One last thing before you sit down, because you asked us to look at tax, and I'm sitting here reading it, and there's just some very odd language in there, which is suggesting that maybe the one party did not ask for leave to amend in the trial court, but then they say that the error was the trial court didn't allow that party to amend. So how do you reconcile that?
I don't.
Okay.
I'm not the smartest.
I mean, I read it very quickly, and I thought maybe you saw something that I didn't see.
No, Your Honor. That's one of the issues that we have here is there's kind of a case law on this issue. So we have to kind of go with what we have. And what it for the court finds that this statute of limitations does affect to, or did affect to, even without a coverage determination. It's not just denial, it's a coverage determination. You have to take a position. And if a typical context, insurance company doesn't take a position, that's action. With FIGA, it's a little different. But in any event, if that does apply here, we would implore the court under tax to give us an opportunity to go back to the trial court, ask for leave to amend, to address that issue, because at the end of the day, there's certainly factual questions of whether or not there was an extension granted, which is expressly contemplated under the statute.
An extension would be something that, an extension of the claims period would be a matter of public record. You're arguing that there's an extension of the claims period?
No, Your Honor, I don't think it would be a matter of public record. It would be a, if I understand Your Honor's question, it's a thing that the case law talks about, whether it be something that's requested and then specifically provided, but there's also, I think, basis for the idea that under a scenario like this, that this is a facto extension, not making coverage determination, not making payment at all until after that period provides. But it's not something that is provided publicly.
Okay.
The liquidation is public and the notice of claim is public, but I don't think that would be. It hasn't been in my experience.
Okay.
Otherwise,
Thank you.
a lot of IRs agree.
Court's going to take about a 10-minute break, and when we come back, we'll pick up with Smalley versus Duke Energy.